You're watching the Estate Planning Series, Heirs Property and Estate Planning Workshop, with Olivia Smith, co-founder of the SR Law Group.
And we're going to be talking about heirs, property, and estate planning today. We're going to get started with some introductions. And so I'm going to introduce Ms. Tisha Curry, who epitomizes energy. Let me say, if everyone could mute themselves, I can hear someone. Tisha Curry epitomizes integrity, energy, hard work, and creative service in every detail of your real estate transaction. As the great-granddaughter of the first African-American real estate agent in the state of Michigan, you can say real estate runs in her blood. This Michigan native relocated to Georgia in 2005. She began her real estate career in new home sales and has expanded her business to focus on assisting home sellers. Her specialty is providing the personal touch throughout the sales transaction. Tisha has made a high-level commitment to her real estate education, having been mentored and coached by several of the most highly acclaimed real estate coaches in the industry. She is a graduate of Ignite and Bold through Keller Williams University. She earned a Bachelor's of Science degree in Sociology from Western Michigan University, a Master of Science degree in Administration from Central Michigan University, and a Master of Science degree in Real Estate from Georgia State University. She is a certified new home sales professional and holds the Military Relocation Professional designation. Tisha is a former member of the Douglas County Board of Tax Assessors and currently teaches undergraduate students real estate principles in the Robinson College of Business at Georgia State University. She serves as the Agent Leadership Council as the Social Equity Committee Chairperson at Keller Williams City Side. So that is Ms. Tisha Curry, who is joining me today.
Thank you so much, Miss Olivia. I get the honor and pleasure of introducing my colleague here. Olivia is a Georgia native and a graduate of Spelman College, where she received a Bachelor of Arts degree in political science. She's also a graduate of Loyola University, New Orleans College of Law. Olivia has been practicing law for 14 years, starting out in criminal defense, but transitioning to estate planning, elder law, and probate as the result of a personal family experience. She is the owner and partner of SR Law Group, a boutique law firm that focuses on estate planning, elder law, and probate in the Black community. She also is the co-host of Black Parents Aging, a podcast that helps children of aging parents navigate the changing landscape. Olivia is very active and engaged in her church and community. Olivia also serves as the Probate and Estates Chair for the Georgia Association of Black Women Attorneys and on the advisory board of Changing How Individuals Prosper. Chip, take it away, Miss Olivia.
Thank you. So every time I get to do a presentation, I get really excited, so there's a train outside. So if you hear a whistle blowing, that's what it is. But I'm so passionate about this work. And so I want to just kind of get you thinking as I go through my presentation. And I want to do that by telling you about a recent case that I had that I feel like really highlights the importance of estate planning. Maybe 2 years ago, I got a call from a gentleman and he said, "I need your help." And I said, "Well, okay, what can I do for you?" His grandmother had passed away. So let's fast forward. Let's rewind. He lived in New York. His grandmother lived in Floyd County here in Georgia. She'd worked for a family for 50 years. She was their housekeeper. She raised their children. But grandma was kind of a boss because she had accumulated properties while working for this family. So she had about 8 or 9 properties that she had accumulated. She started to get sick, and she called for her grandson, who called me later and asked him to come down. And she asked him to contact an attorney so she could do a will. And he thought, okay, how hard could this be? And so instead, he went to the Office Depot and he got the template that said will, and he filled it out according to what he thought his grandma had said. And he thought everything was good, and then grandma passed. Once grandma passed, he started to probate the will. Grandma wanted to leave him and his sister, the properties. They were her only grandchildren. And then he hit a snag because someone filed into the case with another will and said that his will was invalid and the will that they had was the valid will. And that was the family that she worked for. So the family that she'd worked for 50 years produced a will where she was giving everything that she had to them. And this is the part where he called my office, and I won't prolong the story. It was about a year and a half of court filings, litigation, back and forth of us fighting with the family. And in December of last year, it was set for trial. He called the church, the courtroom was full. And we got there ready for trial. I felt good about it. There were some issues with the will he had written, but I felt like, we had enough that we could get around it. An opposing counsel came in and said they didn't want to move forward. They were going to drop the case. It took him probably 3 to 4 times. It cost him 3 to 4 times fighting these people that it would have cost for him to hire an attorney to do the estate planning that his grandma asked him to do while she was still here. And she had an estate to protect, 9 properties. And so that is what I want you to think about as I do the presentation. Not how much things cost, but what is the investment and what needs to be protected, and what is the value of the things that need to be protected. So that is what I want you to think about, and let's get started. So the first thing I want to talk about is heirs property, because we have a tendency in our community, someone passes away and we don't do any of the formal work. Someone moves into grandpa's home and we just keep moving, and the deed is still in grandpa's name and it's 20 years later. And this is really what creates heirs property. It is home or land that passes from generation to generation, resulting in an increasing number of family members owning the property. And so it started out with grandpa just owning it, and then grandpa dies and he had 5 children, and so now 5 children own it, and then a couple of them died and they had children, and so they step into their parents' shoes, and the owners continue to increase and increase and increase. And I've gotten calls from people, and there have been pieces of property where there have been 50 owners. And so when you get to that many people, then what do you do with that property? And so heirs property can be created by will. When you draft a will and you say, I want to leave everything to all of my children equally, that can create heirs property. Or it can be created by intestate succession, when you don't have a will and the state of Georgia decides how the property is going to be distributed. Some of the characteristics of heirs property is co-owners have equal rights to use the property, which can create some chaos and confusion within families. Co-owners can sell their part of the property to someone outside of the family. And so there are situations where you have the bulk of owners being family, And then you have an owner that is not family because one of the family members may have sold their right to someone else. And then certain actions such as selling the property requires owners to agree. And everyone is not going to equally shoulder the weight. This is what I see the most. I get calls and they say, well, I'm the only one paying the taxes. You know, all of these people's name is on the deed, they own it, but I'm the only one paying the taxes. And as you get increasingly more owners, it's really hard to equally shoulder that weight. And so these are some of the challenges when we look at heirs property. And so how can we prevent this from happening? And the answer is really doing thoughtful estate planning. And estate planning is simply making a plan in advance and naming who you want to receive your belongings. That's it. Just making a plan. And so I get this all the time. People are like, well, do I really need to do this? Like, why do I need to plan? Here's some reasons. Because we want to protect your property. We want to take care of each other. The same people that you wanted to take care of while you're alive, those people you can also take care of even in death. We want to make sure that we have something to leave our children. And with a lot of my clients, the children are okay, but who they're really concerned about are the grandchildren. You may want to avoid probate. You don't want the government to get your home. And the last one is you want to have your say. You've worked however long, however many years to have whatever you've accumulated. You should get to say what happens to those things. So some people think you have to be the Rockefellers or Oprah to have an estate. You have to have millions of dollars, and that's simply not true. Nearly everyone has an estate. It is comprised of whatever it is that you own. So your car, your house, other real estate, accounts, investments, sometimes life insurance policies, your personal possessions. All of these things make up your estate. And some of the benefits of planning is taking control while you're physically and mentally able, and leaving your family in the best possible financial situation. And so I'm gonna talk about, and as I talk, if you have questions, feel free to put them in the chat. I am going to go for about 30 minutes, and then I wanna have plenty of time to answer your questions. So I'll have about 30 minutes for questions. I'm gonna go through the documents that I believe create a good estate plan and explain what those are. And then as I talk, you just feel free to put your questions in the chat. So the most common document is a will. I think most of everyone has heard of a will. It's sometimes called a last will and testament. It's a legally binding document that states your final wishes, appoints a personal representative, and that person ensures that your wishes are carried out. And in Georgia, this is what is required to create a valid will. You have to be 14. We haven't upped the age on the books yet, so it's still 14. It has to be in writing. The person creating it has to have capacity. So that means they have to be of sufficient mind and memory, and they have to know and intend to create a will. And then it must be signed by 2 uninterested parties. So that's 2 people who don't stand to inherit from the document. The benefits of a will: it allows you to name the person to receive your property. It allows you to leave burial instructions. And if you have minor children, one of the biggest benefits is it allows you to name a guardian for your minor children. Who's going to take care of your children if you are no longer here? So what happens if you just decide, not to do a will? Don't worry, the state of Georgia will decide for you. So for those people that die what is called intestate, which means they don't have a will, Georgia has created a system by which they distribute your property. And it is a one-size-fits-all system. So it does not take into consideration the particulars of your particular family. It's just, this is how it's done for every family. And so the issue with this is your assets could be distributed equally between your spouse and children. A lot of people think, well, everything will just go to my spouse. That is not true. And specifically, if you have blended families, it is really imperative that you do your planning. Your children may be given an equal amount, but their needs may be different. So say you have a child that is a doctor and you have a child that has special needs. They would get the same distribution, but their needs are different. And so the state of Georgia doesn't take into consideration any of these things. And then probate court may decide who is going to be the guardian of your minor children because you have not done the planning and told the court who you would want. So then they decide who would be best. So opposite a will is a trust. A trust is a legal entity set up to hold ownership of your assets. There's a grantor, which is the owner, the trustee, who carries out the instructions, and the beneficiaries, the people who stand to gain from the trust. A trust can be revocable, which means things can be taken out and put in, or it can be irrevocable, which means once you put things in, it locks. The benefits of a trust versus a will, and I think that's also a later slide, is that the trust avoids probate. It prevents court control of assets if you have some sort of incapacity. So a trust can control while you are alive and after death. It brings all of your assets together into one plan. It provides privacy because when you have a will and you go through probate, probate is a public process. And so people will know what was in the will. They can see what the procedures are, what's going on with this particular case. In a trust, because it doesn't go through probate, it is private. And so the only people that know what's in the trust, the only people that know what your wishes are you who created the trust, the trustee who is charged with carrying out the instructions of the trust, and whoever are the beneficiaries are that stand to gain from the trust. Those are the only people that would know what's in the trust. It also, especially for long-term care planning, as far as irrevocable trust, it allows you to qualify for assistance to pay for that. And so this is the comparison. A will provides your instructions, but unlike a trust, it does not avoid probate. And so I want to be clear because a lot of people think, well, I have a will, that means I won't have to go to probate, or my family won't. A will is a ticket to probate. It means that they will absolutely need to go to probate. And probate is a court-appointed process of reviewing your last will to make sure it doesn't violate any laws regarding how property is distributed. The process can be lengthy and expensive. It is also open to the public. The court system, not your family, controls the process. And so oftentimes I say a will isn't valid until the probate court says that it's valid. And so once it says that it's valid, then whoever is appointed the executor goes about carrying out the instructions of the will, but it's under the probate court is overseeing that process. A trust does not have to die with you and does not go through probate. So one thing that people like about a trust is, especially for parents of minor children, it allows you to shepherd your kids in a way that a will does not give that flexibility. And so for a lot of parents with minor children, they say, okay, well, I want them to have this much at 18, and I want them to have this much at 21 and 25 and 30, and some of them go on to 40. And so what it does is it allows them the flexibility to not give a lump sum to their kids at 18 when they may not be mature enough to be good stewards of what they're being given. It allows them to stretch that out and hope that their kids mature as they age and they are able to make good use of what they're being given. So the will and the trust, even though the trust can be used while you're still alive, we would think of as death documents. Those are documents that determine what happens after I pass away. Now I'm going to talk to you about life documents. So life documents are documents that are in effect while you're still here, but may be incapacitated. And so the first document is a power of attorney. And so why do you need a power of attorney? A will of trust structures how you want your personal and financial matters handled upon your death, but does not plan for the event that you could become disabled or otherwise incapacitated and need help with financial and healthcare decisions. And so a power of attorney allows you to designate another person to speak and act on your behalf in financial and medical situations. You don't lose your decision-making rights when you appoint your agent. You only allow someone to act on your behalf if needed. And the extent of the power of attorney granted to your agent depends on your wishes and the type of agreement you have made. And I will tell you, December of last year, I had a very heavily contested trial for guardianship. Guardianship is necessary often when you don't have these documents in place and you know, a loved one has dementia or something has happened and they cannot handle their business on their own and there's no documents in place. You have to go to the probate court and have them appoint someone. And this was a very contested guardianship case. And I think it's even worse because the person is still alive. So the person is sitting there and they're hearing you say, you know, unkind things about them because you have to prove to the court that they don't have capacity. And in this case, it was siblings fighting over who was going to take care of dad. So they were saying unkind things about each other. And it was really a heartbreaking process. It did not feel good for me, and I'm not a part of the family. And it could have been all taken care of with just dad having done his estate planning while he had capacity. Not only that, the amount of money that this family spent on fighting over who was going to take care of dad was easily 5, 6, 7 times more than they would have paid to have for dad to have his estate planning done. And so that's why it's so important, because we don't know what's going to happen the next day. We don't know what's going to happen tomorrow. We don't know when we're going to, if we walk outside and we get in a car accident or something happens and we're incapacitated and we don't have those documents in place. That's why it's so important not to put it off or put it on the to-do list, and it keeps going further and further down as more urgent things take precedent. So the powers of a power of attorney agent. For financial power of attorney, your agent may be authorized to pay bills, access bank accounts, sell property, handle tax situations, and basically handle other financial affairs in your name. They are considered a fiduciary. They are required to act in your best interests. A medical power of attorney, also called a healthcare directive, the agent is authorized to make medical decisions in cases of mental or physical incapacity. And let me just say right here that it is important to pick the right people, because your documents are only as good as the agents that you select in these roles. So a lot of times parents come to me and they say, well, this person is the oldest. It does not matter. You want the best person. So if the oldest is not good with money, they're always broke, they file for bankruptcy, they're always asking you for money, even if they are the oldest, they may not be the person that you need to select to be your financial power of attorney. And so you have to have a sobering look at the people you love, the people in your family, and pick the right people in these positions. And I tell my clients, it doesn't even have to be a family member. It can be a best friend, it can be a church member, it can be a neighbor. It doesn't matter who the person is, long as there's someone who is going to honor your wishes and there is someone who's going to be a good steward of the power that you have given them. And so healthcare documents, the Advanced Healthcare Directive, it nominates your agent. So that's the person, if you're not able to make decisions on your behalf, that would make them for you. And then in some very specific circumstances, you're also expressing what your wishes would be in these situations. Then there is the HIPAA. The HIPAA does not give the authority to act. It just gives the authority to receive. And so you can put as many people on your HIPAA authorization as you like. These are people who would be able to receive information about you, but your healthcare agent would be the one that would be the only one that could act. Sometimes people call the office and they ask about a living will. That is not a thing in Georgia any longer. The healthcare directive does both things now, and so it's just that one document. And then sometimes people ask about DNRs. That is usually done not with attorneys, that's usually done with your healthcare professionals. And so a do not resuscitate order is not something that we do. So here are some common myths that I hear. Appointing an agent means I'm giving up control. And that is a real concern for people, that they are giving up control to make their decisions. And that's not the case. The only time these come into play is if you are unable, you don't have capacity and you're unable to make those decisions. I already have documents, so I don't need to think about it again. Also not true. So your documents have to be a living and breathing thing, and they have to reflect your life. And so if you got, a will and all of these documents done 20 years ago, and your life looks drastically different from how it looked 20 years ago, you probably need to update your documents. And as life happens and as life events happen, you get married or you get divorced or you have children, or you gain more property, there's so many, or people that you've named, they pass away, or y'all have a falling out and you're not as close. You need to be analyzing your documents to make sure that they still reflect your current life. And then my next of kin can decide whether to pull the plug. And then my loved ones know what I want when you haven't talked about it. So they really don't know what you want. And that is a really difficult situation to put a loved one in, trying to figure out if they're making the right decision, when you can have these conversations with them now and then memorialize it in a document so they can be sure and they can have the peace of knowing that they did what it is that you wanted them to do. And as I said before, the best time to plan your estate is now. When major events happen, we don't want ourselves or family to be unprepared. Estate planning is an ongoing process, and your plan should be reviewed every 3 to 5 years and updated if necessary. And we just don't know what is going to happen around the next corner. And so we have to be prepared. And so, estate planning is one of the things that get put on the to-do list, and then it keeps getting moved down. and we need to make sure we put it on the to-do list and keep it at the top. And that is it for my presentation. We do have a workshop coming up next month in Douglasville, Tough Conversations with Aging Loved Ones. Tisha, did you want to talk a little bit about that?
We're going to give you more information about it. We've gotten a lot of questions about how do we go from having to have this conversation to how do we actually do it, and what are the things that we need to have in place once we have that conversation. So we're going to send you more information about that in-person workshop over the next few weeks. We wanted to let you know that we have it on the schedule. Also, there is a survey at the end where you can chat with us a little bit about your experience here, and you can let us know what questions you'd like to have us answer for you prior to that event.
So this is a save the date. So that's Saturday, March 18th at 10. I think it's from 10 to 12. So save that date and time so that you can come out. And then stay in touch. I will tell you, for everyone that is registered for this event, I am going to send you out an email. It is going to have, I guess I can stop sharing. I'll give you a second to get our information. And then I'll figure out. Gonna stop sharing. Okay. I am going to provide a coupon in the email that I give out for a consultation. So our consultations are usually, for my law office, they're $250. I'm going to provide you with a coupon in there. If you are interested in having a consultation, we do require you to fill out a questionnaire as well. And there will be an expiration date on the coupon. But I feel really strongly about everyone getting their estate planning done. So we do estate planning, we do elder law, which is long-term care planning. We do probate work. So if you've had a loved one to pass, we don't want an heirs property situation. So instead of doing nothing, you need to see, okay, does their estate need to be probated? So these are things we need to do a better job of, and we are here to help you. And so with that, I will open it up for questions.
You can please put your questions in the chat. I have a question for you, Miss Olivia.
Okay.
So I have a case where we're in an heirs property situation. There are two surviving siblings, so two children. There is no will. One parent passed away in the 70s and the other passed away in 1994. The property did not go through probate. Who has the authority to sign to sell the property?
How many children were there originally?
5.
So this is where it gets fun in probate, because what it requires when you have heirs property, you got to go all the way back. So you say, okay, the first parent died in 1974. Okay, so first parent died in 1974 without a will. So that means whatever they own a third would have went to the spouse, 2/3 would have been shared by the kids, right? Then you go and you have to go all the way down. Then the second spouse died in 1995. Okay, ideally that leaves 5 children. So if some of those children have passed, that means their children step into their shoes. And that is how you keep getting more and more heirs. And so it's not just the 2 that are surviving, it's also the children of the ones that have passed. And so it's going to require them to open probate and have an administrator appointed. And then that person will act in the best interest of the estate with multiple members, it's going to make more sense to sell it, and that person can sign off. The administrator will have the power to sign off on a sale, on a contract. But that is why it gets complicated.
Thank you for that. We have another question. The question is, I already have a trust and I purchased another property. Will I need to do another one or an amendment?
You should need to do either. You just need to, if you purchased a property, the deed needs to be in the trust name. And so that's how we fund the trust. After we have a trust established, every time we gain an asset, instead of it being in our name, it needs to be in the trust name. And so if you bought the property and it's in your name, a new deed just needs to be done to transfer it from your name into the trust name.
So that, to piggyback off that question, if you're purchasing a property and you're getting a loan on that property, you have to close in the personal name of whomever is buying that property. Then you have to do a subsequent deed to add it to the trust. Is that correct?
That is correct. I don't know about the closing part, but yes, you can do a subsequent deed to add it to the trust, for sure.
So that, I'm telling you about the closing part.
Yeah, that's your expertise. Letitia said you need, so yes, but then you would need to do it in the trust name, and I will tell you why, because the whole point of a trust is we want to avoid probate. So avoiding probate means there is nothing in our name, because in essence, probate means we are removing something out of a deceased person's name into someone's name that is living. And so we don't want to have to deal with that. That's why we have a trust. So we need to get it in the trust name.
Thank you very much. We have another question. Does doing a live recording with intentions or reading a will add more weight to the will and keep it out of probate? Would you like me to read it? Did you get it?
No, so it really just depends. And I'll tell you why. Because if you have a will and it's written, because it's required to be written, and someone wants to challenge your will, and there's a recording, I guarantee they're going to find something in that recording that backs up why they feel like you didn't have capacity, or why they feel like, there was undue influence. And so the instinct is to do that, but I think if someone wants to fight you, they're going to find a way or a reason or something in the recording or something in the video as reason enough to object to the will in probate. So we don't do those. You just want a well-written will and make sure that it has all the requirements, and that should be sufficient.
Okay, we have another question. I just want to remind you, and we'll put it back in the chat again, that we have a survey about today's recording, and we'll ask that you give us some feedback on additional questions. And if we miss you today, or if you have something else that you'd like to go further with, we will address that for you after the fact. So next question, do you assist with estate planning outside of Georgia?
No, so we are licensed in Georgia, but we have referral partners all over the place. We try to we try to do a good job of that. So if we can't help you, we can refer you to someone in your state that can help.
Okay, next question. That's a great question. Thank you. With a trust, does it qualify someone for assistance to pay for long-term care? Can you explain that a little bit?
Yeah, so it is a specific type of trust. So Medicaid is the only program that I know of that fully pays for nursing home care if you need to go into a nursing home. However, it is means tested, which means you have to have a certain level of assets, be below a certain level of assets, and a certain level of income. And so what I didn't know until I started doing this work is there's ways around this. And so one of the ways around it is long-term care planning. And that is a lot of different strategies. One of the strategies is using an irrevocable trust, an asset protection trust. What that does, whatever you put in that trust, it locks and you no longer have access to it. The benefit of the trust is if you want to make sure the grandkids get whatever you have for them, or you want to make sure your kids get whatever you have for them, the trust will make sure that it goes upon death to whoever you want it to. You can't access it during life. And because you can't access it during life, after the Medicaid 5-year look back, it's not considered your asset. And that is how a lot of people that have a good amount of money are able to qualify for Medicaid, but still have put their assets away to go to their kids or go to their grandkids or charity or wherever they want it to go to, but still be able to qualify for Medicaid to pay for their long-term care. There are other strategies as well, but that's the basic trust strategy for that.
Thank you for that, Ms. Olivia. We have another question. Can funds/bank accounts be added to a trust?
Yes. And so in the same way, if property is added by retitling, you would go into the bank with your certificate of trust, and instead of the bank account being in your name, it will be in the name of the trust.
Thank you very much. So we have a kind of part 2 to the question about the recording. So if the recording is done while I'm assuming the person is young and of capacity, does it make a difference?
No. So the recording for the will, I'm guessing you're talking about?
Yes.
So for there even to have been a will, you have to have capacity. So my only point is if you are taking the extra step as far as saying, okay, I'm gonna do this recording and I know nobody then can say anything about the will, that's probably not the case. If there is someone in your family that feels like, there is something they should have had, regardless of whether there is a recording or not, they can object. Now that recording can be used as evidence, either for or against the validity of the will. But I don't think that would keep someone from objecting to your will if that's what they want to do.
Thank you. Another question. Says, I have a family member that had the statement of, if anyone contests my will, they will only receive $1. Is this better than saying that they get nothing? And if so, why?
It's a non-contest clause. No, I mean, $1, nothing. But the only way that has teeth is if they are already going to get something. So say, okay, I'm leaving you the car, and you're like, I'm just getting a car. I was supposed to get the house too. Well, if you contest, you won't even get the car, right? But if I'm leaving you nothing already, that has no teeth. Because if I win, at least there's a chance that I'll get something. I've been totally left out the will, so that has no teeth, because if I challenge, I'm not gonna get anything. Well, I'm not getting anything now anyway. And so really it only has teeth for people that are already in the will receiving something, but maybe they feel like they should receive more than they are already getting.
Great, thank you. We have another question. What is the approximate cost of a trust?
So I'll tell you what my cost. I'm sure you can, call other attorneys and they would have, other costs. A revocable trust package at my firm. So that's the trust, that's a certain type of will, that's the healthcare directive, power of attorney, HIPAA release. It's $4,950. Oh, and the deed. With a trust, I will say it's more expensive up front and the work is done up front, because once you get a trust, you then have to retitle your assets into the name of the trust. With a will, it's cheaper up front and the work is done on the back end. However, with clients that come to me that want me to probate their loved one's estate because they have no idea about the probate process and it can be a little tedious at times, me to probate an estate costs more than for you to get a trust. So if you get a will and then you need an attorney to probate your estate, you're going to pay more than if you would have just paid for a trust up front.
Okay, so this person says they have property in multiple states. How does a trust work? Are there two separate trusts? Are there trusts in every state? How does that work?
So if you live here, your trust will be the situs is what it's called, is the state in which you live. So if you live in Georgia, your trust will be drafted and executed in Georgia. What does require work from other attorneys from other states is the deed work. And so, for instance, I'll have an attorney reach out to my office and say, hey, I'm drafting this trust in Florida. They have a property in Georgia. Can you do the deed work? Which means, can you draft the deed putting their Georgia property into the trust and get it recorded in Georgia? And so for every state that you have a property for, we would need to reach out to an attorney and say, hey, they have a property in this state. Can you do the deed work to put it in the trust here? And that is all that would be needed. It would just be one trust.
Okay, we got some good questions. I love it. I have a question before we go to the next.
Okay.
So, mom and dad own a home, but it's not paid off. There is a mortgage, and mom and dad want to leave the home to someone in their family, but there's still an outstanding mortgage. Who's responsible for this mortgage, and who owns the home? Can you talk a little bit about that? I'm sure you can. I have a take on it, but go ahead.
So, okay, if mom and dad have passed, they passed, and now there's this home that has the mortgage. Who owns it? They left it to someone?
Yes.
So, is it in the trust, or is this a trust, or is this
no
a probate?
trust? You're talking about
probate.
Without paperwork.
Okay, gotcha. So what happens is, what everyone needs to know is in Georgia, even if you are going through probate, they can foreclose on that house. So that's number one. So somebody has to keep paying the mortgage while you're going through probate. And I really want to petition the state legislature about this, because I feel like it is against poor people. Because if you're just making ends meet, you don't have extra money to then pay for somebody else's mortgage when you barely pay your own. But that, I won't get on that soapbox. Somebody has to continue to pay the mortgage, because they can foreclose on the home while it's going through probate. And oftentimes, the home is the most valuable asset. Okay? Most of the time, the home is the most valuable asset. If it's gone, there's nothing else. And so what would happen is, once the court appoints an administrator, the administrator, depending on, is there a will in this scenario or no will?
There's nothing.
Okay. So depending on what the estate looks like, right? Are there creditors? Are there people that need to be paid? Because if there are people that need to be paid, they're gonna have to sell the house. So the administrator would sell the house, pay off the mortgage, and whatever proceeds were left would go into the estate account. And then before anyone gets a distribution, creditors have to be paid. And so then they would go about paying off any creditors, and whatever is left would be distributed to the beneficiaries.
Thank you. Next question. Executor of property of origin refuses to cooperate and sign corrective deed with proper legal description. It was an administrative error. He has to be compelled to administer his duties or be removed. What's the best strategy to deal with the administrator?
So you have an administrator or an executor who's not acting? Is that the question? Or who's failing to act?
That's how it appears.
If you have an administrator or an executor who's failing to act, you file a motion in probate court to have them removed. And I've done that before.
So
go ahead, Walt.
Okay, thanks, Tish. So I mean, this is more of a friend's situation than it is mine. So really, they should be here. But since you're answering questions, I want to pose this question. But yes, the administrator is refusing to cooperate just to block the sale, and of course, probate court is notoriously slow in Fulton County. So, just any tips?
Notoriously slow.
Yeah. So, any tips that you can have that I could pass on to this friend and maybe introduce y'all?
Yeah, I mean, you can definitely introduce us. Fulton County is not my favorite county. But you know, in their defense, it's one of the biggest and busiest counties. We send our paralegal down there once a month with a spreadsheet because that's how they make sure that our cases are moving along, that they see our face. How is it getting sold if the administrator does not want to sell?
Well, see, that's the thing. They can't sell. So this property is from a few generations ago. My friend and his wife are the heirs. That's not questionable. He is the cousin that lives along the border of the property, but he's challenging the property line and blocking the sale.
And he's the administrator?
Yes. As far as I know.
I want to jump in here, Walter. I just put the link to the form in the chat. I want you and Olivia to have this conversation kind of offline. Okay. It's going to be a little bit more detailed than maybe what everybody is here. But I want you two to connect. So Walter, make sure I send it to you directly, okay?
All right, thanks, Tisha.
All right, you're welcome. Let me go to the next question. What if you currently don't have property? Should a trust be set up now or once you get property?
Do you have other things to go in the trust, bank accounts? It also depends on what your family makeup is. For instance, I do trust for parents all the time that have minor children. It's not because they have property or not. It's because they have like $1 million life insurance policy and they don't want that to potentially pay out to their kids. So the trust becomes the beneficiary of that policy. So it just depends on why you would want to trust and what you would use it for, whether you need one now or whether you can wait.
Awesome. Thank you for that. So we have another question. If my husband and I need a trust, is that 2 fees or 1? And the second part of the question is to add, all of our assets are joint and we have 2 kids.
Okay. So want to make sure that you don't have a blended family. So you only have the 2 kids, husband doesn't have any kids that are just his, you don't have any kids that are just yours. So you can do a marital trust, and it's not 2 trusts. There is a couples fee that I don't know right off the top of my head, but you can do a marital trust. It would be 1 trust, a family trust, but then it's 2 wills, 2 power of attorneys, 2 healthcare directives, and 2 HIPAAs. So those things have to be separate, but the trust can be together.
And I also put the link sent that directly to the person who answered that question to reach out to you further. The next question, if I added my daughter to my deed, would that avoid probate?
So, and I don't know if Tisha knows about the step up in basis. So yes, that does avoid probate. So check to that. But there are some benefits to things being passed, to you inheriting something through death, tax-wise. It's called a step up in basis. And so when people do that, it may still make the most sense for you, but I want you to understand that there is a tax consequence there and a tax benefit from your daughter inheriting that she would not get if you just add her to the deed.
Not only that, but in Georgia, if your daughter's married, inherited property and they split, inherited property is not a marital asset, whereas your daughter just being on the deed itself and something happens to you, it does become a marital asset. So you don't have to go through probate. However, there are some other nuances that you want to consider if the intention is protection. We had some great questions. Oh my goodness. Thank you so much for participating. One of the things that Olivia did mention is that your home generally is or real estate is generally the most valuable asset in estate planning. And so along with Olivia sending you that certificate for the consultation, I also will send you in the link that you can also have a free home evaluation to see where you are right now, understanding the value of the homes or any homes that may be in your state. That you have a question, that the home can be anywhere in the United States. I can help get you information on that value. It could be multiple homes. It can be your parents' homes. It can be your friends' homes. Wherever information you want to know about what's happening in the real estate market with regard to how it relates to probate and value, I will send you a link for that as well. You just fill out the survey and put in your information, and we'll follow up with you after this call.
And that's really important, because you want to be able to make informed decisions about who you're leaving what to, exactly what you're leaving, the value of what you're leaving. And so that's really important.
We talked about this too, I think, when we were talking about siblings, and we were talking about the oldest, and this one should get the house and this one. So can you talk a little bit about like kind, and really kind of, what was the word that we talked about before? Equitable,
not equal.
Yes. Talk a little bit about that.
So that is important. Oftentimes parents come and they say, okay, I have 3 children and I want to leave a third. And immediately I'm like, that is not a good idea. But they want to make sure that their children know that they love them equally. And so what I tell clients is, you can be equitable without leaving everyone the same thing, being equal. And so if you have a child that feels the same way about this farmland that you feel about, then maybe you should leave that property to them, because they're going to be a good steward. If you have a child that is already living at home with you, taking care of the bills, taking care of you, and your other children live out of state, have families, have their own lives, maybe you leave that piece of property to the child that is there in the property. And so that doesn't mean that you leave the other children out. Maybe they get more in the life insurance policy, or maybe they get more on the 401k. And so you can be equitable and make sure that everyone inherits without leaving 5 owners of one single home. It's not a good idea. And I tell my clients, did they fight when they were younger? Nothing has changed. And when you're not here, that is what is going to happen. And so the whole point of doing estate planning is to make things simpler, is to make it easy, is to cut down on chaos and confusion. And so we don't want to draft documents that do the opposite of that. And sometimes that really does mean that we have to be realistic about the children we love, or about the family that we have, and make those really tough decisions when we're planning. I will tell you that the most contentious cases that I have had to date, and I just got another one, are surviving spouse and children that are not surviving spouses, those blended families. And the spouse always says to me, we had such a good relationship. I've known them for 20 years. I cannot believe that they are doing this. Don't matter. Inevitably, people put up with people because they love you. And when you're not there anymore, their true feelings come out. And so you have to have those real conversations and those realistic views and looks at your family and how you want to craft your estate planning, so it cuts down on confusion and doesn't cause more confusion.
This has been awesome. Thank you so much. We thank you so much for taking time out of your schedules to come and just spend a little bit of time with us. We're here all about educating our community and protecting the things that we've worked so hard for, so that every generation after us does not have to start fresh. Not only that, we'd like to keep as many of our assets in our community and not giving them away to the government just simply because we were uninformed. So Olivia and I have made it our mission to inform our community, and we're going to continue to do so. Please, please, please fill out the survey and give us your feedback on how we can help you, and be looking for additional information about our tough conversations with aging loved ones next month. So thank you so much. I'm going to stop recording now. Hold fast, Olivia. Thank you all so much for coming.
Thank you, guys. It was great. I love good questions.